we would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that, a president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable.
But since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted at least
Counsel,
private conduct.
on that score, there does seem to be some common ground between you and your colleague on the other side, that no man's above the law, and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible, that that would be within his right to do?
Absolutely, Your Honor.
Knowing that the slate is fake, knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state, he knows all those things.
And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but that sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized.
What is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official acts?
The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a 2-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, I mean, that's like a one-legged stool, right? I mean, giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become the ambassador to a particular country, that is official, the appointment. It's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward.
In assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute, essentially, the blazing game discussion of that.
Okay.
But of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this.